You're staring at a glowing screen at midnight, completely exhausted. Your mind is racing because your boss called you into the front office today and fired you. The manager said you committed misconduct, and now you're terrified because the rent is due on Friday. You immediately wonder if you can even get unemployment benefits. That's exactly the question we're tackling right now. We're going to walk through the actual rules of the unemployment system, so you know exactly how this machinery works. Keep in mind, this is education about how the general system operates, not legal advice for your specific situation. Laws change constantly, and they vary wildly depending on exactly where you live. Let's answer the questions you're asking yourself right now. The very first question ripping through your brain is simple. What exactly does misconduct mean when it comes to getting unemployment benefits? It feels like a boss can just throw that word around to block you from getting your hard-earned money, but the law actually has a very specific definition for this term. Misconduct generally means a deliberate or extremely careless violation of the reasonable rules of your employer. It means you did something you knew was against the rules, or you showed a total disregard for the safety and success of the business. An honest mistake is absolutely not misconduct. If you're a warehouse worker and you accidentally scan a pallet of goods to the wrong zip code, that's just a normal human error. You were trying to do your job right, but you messed up. The unemployment office calls this simple inefficiency or an isolated incident of poor judgment. You can still get unemployment benefits for making an honest mistake. Carelessness crosses the line into misconduct when it becomes gross negligence. Gross negligence means you showed a complete and extreme lack of care for the safety of other people or the property of the business. If you drive a delivery truck and you decide to read a text message while flying down the highway at 70 miles per hour and you crash the company vehicle, that's gross negligence. You ignored a basic safety rule on purpose. Your state unemployment office will weigh what happened. If you broke a minor rule, like showing up 10 minutes late twice in a month, that rarely disqualifies you. If you broke a major rule that puts the company at serious risk, you might lose your benefits. The key distinction is always whether you made a genuine effort to do your job properly or if you simply didn't care about the rules. The next giant question is probably keeping you awake right now. Does being fired automatically mean you can't get a single dime of unemployment? This is the biggest myth floating around break rooms everywhere. People think that getting fired acts like a giant steel door slamming shut on your unemployment check. The truth is actually completely different. The system doesn't care that you were fired. The system only cares about why you were fired. Unemployment benefits are designed for people who lose their jobs to absolutely no fault of their own. When you file for unemployment, the state agency doesn't just take the word of your boss. They open up an investigation to determine the actual reason your employment ended. If your boss fired you because the company lost a massive contract and they needed to cut staff, that's a layoff. You'll qualify for benefits. If your boss fired you because you weren't fast enough at assembling parts on the assembly line, the state will likely determine you were fired for inability to perform the job. That means you still qualify for benefits. You get benefits unless your employer can prove you committed actual misconduct. Proving that misconduct is actually very difficult for an employer. They can't just tell the unemployment office that you had a bad attitude. They have to provide actual documentation. They need time cards, written warnings, or witness statements. If the employer can't prove that you broke a known rule on purpose, you win the claim. This process varies heavily by state, so you must check your local agency rules. You might be asking another dark question. They're saying I broke a serious safety rule on purpose, so I just give up and walk away, right? You absolutely don't give up. Employee handbooks are often written by corporate lawyers to scare workers into compliance. These handbooks usually say that if you get 3 written warnings, you're automatically fired for misconduct. The unemployment office doesn't blindly follow corporate handbooks. The state cares about the actual final incident that caused you to lose your job. If you were late twice, got warned, and then your car broke down on the highway a 3rd time through absolutely no fault of your own, the state looks at that specific day. If you acted responsibly on that final day, you still have a very strong chance of getting your benefits approved. The state also looks closely at how your employer enforced the rules. The legal term for this is disparate treatment. Disparate treatment means an employer punishes one employee for breaking a rule, but lets another employee break the exact same rule without any punishment. If your manager fired you for being 5 minutes late, but routinely lets the morning shift supervisor arrive 30 minutes late without consequence, that's disparate treatment. You can use disparate treatment as a massive shield during your appeal hearing. It proves the rule wasn't actually a firm company policy, but rather an excuse to get rid of you. When you prove the employer acts hypocritically, their entire case regarding misconduct starts to crumble completely. Judges hate seeing favoritism, and it destroys the credibility of the management team. Of course, there are clear lines you can't cross. If I stole cash from the register, I'd definitely lose my benefits, right? You absolutely do. Certain actions disqualify you from receiving benefits almost instantly in every single state. These are things like theft from the company, committing actual fraud on the job, or failing a mandatory drug test required by law. Theft means taking company property without permission and intending to keep it permanently. If you take a $50 tool home from the job site and forget to return it, that might be an honest mistake. If your boss catches you loading company power tools into your personal truck to sell them online, that's undeniable theft. You won't get unemployment benefits for stealing. Failing a drug screen also trips up a lot of hard-working people. If your company has a published drug policy and you fail a random drug test, that's usually considered severe misconduct. However, even with drug testing, the employer has to follow the exact proper procedures. If they use a cheap, unverified testing kit and can't prove the chain of custody of your sample, you might still fight it. Chain of custody is the documented paper trail showing exactly who handled your test sample from the moment you gave it until the moment they tested it. If that paper trail has gaps, the results are useless. Now you're looking at the massive stack of paperwork for your initial claim. If my employer uses lawyers, I need to hire a lawyer immediately, right? The unemployment system is specifically designed to be used by everyday people without formal legal representation. The judges speak in plain English and guide the conversation along. You can absolutely represent yourself and win your appeal hearing. You only need to hire an attorney if your case involves thousands of dollars of past wages, or if your employer is falsely accusing you of committing actual crimes like embezzlement. When you reach out to a lawyer, they'll usually tell you to file the initial claim completely on your own. You can always bring an attorney into the picture later if the case gets incredibly complex. You just need to tell the truth during your hearing. Stick strictly to the facts. Bring your evidence, take a deep breath, and explain exactly what happened on the day you were terminated. Don't get angry, and don't insult your former boss. The judge listens to dozens of these cases every day. If you sound calm, organized, and reasonable, you instantly have a massive advantage. Now you know exactly how the machinery of the unemployment system operates. You know that getting fired doesn't destroy your right to collect money. You know the state forces the employer to prove you intentionally broke a major rule. You understand how to use disparate treatment and mitigating circumstances to protect your wallet. You've the power to fight back against a false accusation. What is the absolute worst reason a boss ever gave you for firing you? Tell me down in the comments. If this breakdown gave you the real truth about protecting your hard-earned money after an unfair firing, pass this video along to a coworker who is currently sweating over how to pay their rent next month. Make sure you subscribe to Scribble Law so you always know the exact rules of the game before a shady employer tries to use the system against your family.